Good evening and welcome to our panelists, audience, including our online audience and our co-sponsors, Loud Light, Kansas Interfaith Action, Mainstream Coalition, League of Women Voters of Johnson County, League of Women Voters of Douglas County, Lawrence, and League of Women Voters of Wichita Metro. We also want to recognize our online watch party at the Bonner Springs Library in partnership with the Bonner Springs NAACP and the League of Women Voters of Johnson County. Thank you for joining us. This is the second in a series of educational events these partners are hosting before the November 8 election. Please join us in person or online for our final focused event on the final event focused on the constitutional amendments on the ballot. On that event is November 3 at WSU. We're recording this and we'll make this available after the event. There will be a time for questions at the end of the program for a few audience questions. Volunteers have note cards where you can write your questions, raise your hand, and we'll bring those note cards to you and collect them before we begin the Q&A. Online audiences can use the Q&A feature of Zoom. Our moderators tonight are Sahej Harmer, him. He is currently a freshman at University of Kansas studying sociology with a minor in political science, and Faith Lopez, they, is studying social welfare at the University of Kansas with a minor in women, gender, and sexuality studies.
All right. So this November, Kansas will be asked to vote on two constitutional amendments that would shift the balance of power in our state. The First Amendment would increase the power of the Kansas legislature by allowing them to overturn any administrative agency decision with just a majority vote. And Amendment 2 would mandate the election of county sheriffs that would give the Attorney General the authority to initiate the recall of county sheriffs from office. Tonight's panelists, Amy Castile and Emily Depew, will explain what a yes and no vote means on these amendments and the importance of your vote on November 8th.
Amy Castle is a professor at KU where she teaches law and business school. Amy also teaches constitutional law at KU's political science department. Before teaching, Amy practiced law in downtown Kansas City for 2 decades, where she also clerked for 3 federal judges. Amy devoted much of her time volunteering for her county party, where she has been a board member of the ACLU of Kansas for 5 years. Emily Depew is a third-year law student at the University of Kansas School of Law. She received her Bachelor of General Studies in History, Political Science, and Women's Gender Sexuality Studies at the University of Kansas in 2020. Emily has worked at the Robert J. Dole Institute of Politics since 2016, where she has served as the Student Advisory Board Coordinator from 2018 to 2020. Emily is a 2-time moot court national champion and a co-chief justice of the Law School's Moot Court Council.
All right, let's start off this conversation with some context for what we'll see on the ballot. We had a constitutional amendment on the August ballot, and now we have 2 new constitutional amendments on November 8th. Why are we seeing so many high-profile constitution amendments for Kansas voters lately? And what does this mean for our Constitution?
Well, hi, Amy Castle here. So we're seeing these constitutional amendments because our legislature is proposing these constitutional amendments. And so for a little bit of context, every state has its own constitution. Most people know that we have a federal constitution, and every state has its own constitution. Now, those state constitutions, they can't take away rights that are guaranteed in our federal constitution, they merely add to them. So in Kansas, we have a state constitution that was enacted or ratified in 1861. We have amended our state constitution 98 times since then. For context, our federal constitution that was ratified in 1789 has been amended 27 times. So we have amended our constitution, our state constitution, quite a few times, but the process to get an amendment on the ballot is that 2/3 of the legislators or Kansas legislators have to agree to put it on the ballot.
Thank you so much. We're going to focus on the proposed legislative veto amendment first. What is this proposed amendment and why is it on the November ballot? Yeah, I can start off. Thank you so much for the League of Women Voters and also Loud Light. Faith and Sahej, thank you so much for moderating. I think it says a lot about you as undergraduate students taking this on. And so I appreciate being asked to come here today to talk about these amendments. And of course, as Faith had brought up, the legislative veto is on the ballot. And essentially what the legislative veto is, if you look at the text of the amendment, is that it allows the legislature to revoke or suspend any rule or regulation promulgated by a administrative agency within Kansas. There are several reasons why there were proponents and opponents of this bill, and I'm not sure before it became an amendment on the ballot. Do you want us to get into that, or do you? Yeah, absolutely. Yeah, sure. And so I'd say a great source to look at for both the sheriff's amendment and the legislative veto, obviously, is the Kansas legislature website. There you can locate testimony of both proponents and opponents of this bill. And if you look at the proponents of the amendment itself, you'll find that there are a lot of groups and organizations within the business and agricultural areas, due to the fact that a lot of them had testified that in their testimony for the bill, which was the House Concurrent Resolution 5014. And they cited that there was a high level of regulations in which their members must operate. And they alluded to an excessive nature of the regulatory state. So that is one reason why some proponents in the proponents of this amendment in the business and agricultural sectors have promoted this amendment to be on the ballot. On the other hand, there were several opponents of the bill as well, who stated that the legislative oversight of administrative rules and regulations is the legislative oversight of it is inappropriate, they believe. And of course, there are several other reasons why these proponents and opponents discussed their favorability or their unfavorability against this amendment. But I don't want to take the room too much if you want to discuss any more, Professor Castle.
Sure. Thank you. That was a great explanation. And one thing to keep in mind about this amendment is that one of the reasons, if you look at the purpose of the amendment, if you actually go, it will be on your ballot, and it will say, we want to give the legislature a mechanism to be able to revoke or suspend administrative agency rules. So we're talking about executive administrative agencies. Those are the agencies that are tasked with promulgating rules and regulations, right? So let's talk separation of powers, right? We've got our legislative branch, which makes the laws, our executive branch, which enforces the laws, and then our judiciary that interprets the laws. These executive administrative agencies fall under the executive branch. We have 13 official administrative agencies in Kansas, agencies like the Department of Health and Environment, the Department of Agriculture, the Department of Labor. So these agencies, who presumably have experts working for them, they pass rules and regulations. So the legislature currently has the power to revoke or suspend agency rules and regulations. They have the power to do it like they have the power to do anything else: pass a law. So if an administrative agency passes a rule or regulation that the legislature does not like, they can revoke or suspend that regulation, but they have to do it like they always do things, right? They have to pass a law, which means there has to be a legislator who proposes a bill. It goes to the House and the Senate, and 51% legislators agree to revoke or suspend that regulation, then it goes to the governor's desk, right? And the governor has an opportunity to veto that law. If the governor vetoes it, it goes back down to the legislature. And if the legislature has a supermajority or a 2/3 vote, they can revoke or suspend that law. So the legislature currently has the power to revoke or suspend agency rules and regulations. So what this amendment, a vote yes on this amendment, would take the governor completely out of the equation. So if 51% of our legislators believe that a rule should be revoked or suspended, 51% will have the power to revoke or suspend those rules and regulations. And oftentimes, think about the rules and regulations that are promulgated by the Department of Health and Agriculture. Those are rules that are supposed to protect our health and safety. And so this amendment would take power from the executive branch, take power from the governor, and hand that power to 51% of our state legislators.
What would a no vote or a yes vote mean? Basically, what are you voting for essentially?
You want to take this or?
Go ahead. I'll start off, and I had said this earlier, I will always defer to Professor Castle. She's the resident expert here. But something to keep in mind with almost all constitutional amendments is that if you vote no, you're maintaining what is already in our Constitution. A vote yes would be an amendment to the Constitution. So that's something to just keep in mind. If you're a status quo type of person, you want to consider voting no. But I would say that a really great example of what a yes or no vote would be to look at other states where the legislative veto is enacted, which includes states like Idaho and Connecticut. Both of those states did have a legislative veto that did pass. And I think that they're representative of what the legislature in those states have done with this newfound power. As Professor Castle had stated, there is no presentment to the governor under the legislative veto. Back in 1984, the Kansas Supreme Court had already decided that the lack of separation of powers in the legislative veto and the lack of presentment to a governor. If you think back to your School of Rock days, where there would be the "I'm just a bill," you think of it going from the legislature to the president or governor in this case, and it getting signed. There wouldn't be any transition from the legislature to the governor. There wouldn't be any presentment in that case. And when that was passed as a statute by the Kansas legislature in '83, the Kansas Supreme Court came back and ruled it to be unconstitutional. And so that's obviously one of the reasons why it has to be a constitutional amendment. It can't be a statute, because the only course of action here for proponents of this type of amendment is to either get the Kansas Supreme Court to hear a case like this again and to take back their previous ruling, essentially, or to have a constitutional amendment pass. And so essentially this has been tried and has failed in Kansas before, but certainly, as I stated earlier, there are a lot of proponents of this in Kansas. So there is steam, at least on one side of it, to get it back on the ballot for this upcoming election. But on the other hand, there are a lot of opponents of it as well. So like I said previously, I would really encourage people to go to the Kansas legislature website, where you will find testimony from various groups about whether they view it favorably or unfavorably. And I think that would be really insightful to each individual's own affiliations, own ideology, to figure out where they feel comfortable voting.
Very good. And actually, I'll just go ahead and hand it back to you.
Okay.
I was going to say.
No, thank you so much for that answer. And this is the last question that we will have for this specific amendment. If this passes, what happens next with the legislator?
What do you mean what happens next if it passes? So what would happen if it passes? Then the legislature will, well, and not to say anything political, but let's face it, in Kansas, we have a Republican-led legislature. And so Republicans have a reputation of not liking regulations, right? So the concern would be that our legislators would, begin trying to revoke agency rules and regulations that protect us. And these are lawmakers, right? They're not experts in their field. And so that's one of the concerns, is that you're going to have these legislators, these lawmakers who are going to decide, well, this regulation's good, this regulation's not good, right? And it's not their area of expertise.
I echo everything Professor Castle has said. I'd also add, I think that there are some people out there who think that maybe it wouldn't change a lot because the legislature already has the power to review administrative rules and regulations. They don't have the power to suspend or revoke those regulations, which is on the amendment, but they already do have the power to review. And so, as Professor Castle stated, you know, that there would be more happening in the legislature regarding that revoking or suspending, but they already do have the power to review these types of rules and regulations.
Thank you for that, both of you. Those were great explanations. Let's turn to the second proposed amendment now. What is the Sheriff Constitutional Amendment and why is it on the November ballot?
Well, I'm going to put aside the why is it on the November ballot, because I think, you know, there's some political history, recent political history in Kansas, why our Republican-led legislature proposed this amendment. So the why, what I'd like to talk about is what it is, what we'd be voting for. So this amendment deals with sheriffs, how we elect our sheriffs in Kansas and how we remove our sheriffs in Kansas. So the first has to do with the election of sheriffs. And so what the amendment says is that going forward, that all counties have to have as their head law enforcement person an elected official, as in a sheriff. Now, we have 105 counties in the state of Kansas. 104 of those counties already elect their sheriffs. One county, Riley County, back in 1974, consolidated their county and their city government. And under state law, under Kansas state law, if you consolidate your county and city government, then there is no elected sheriff. Rather, there's a police, a law enforcement board that's created. People are appointed to the board and they choose the police director. By Kansas law, that's how a consolidated government works. So one county currently has a consolidated government. So 104 counties already elect their sheriffs. So this amendment would require going forward that even if a county and a city decide to consolidate their government, they still have to have an elected official as the top county law enforcement person. So it would require going forward that notwithstanding a consolidated government, that there would be an elected sheriff in that county. So that's the election part. The removal part is a little more complicated, a little more nuanced. I'll try to break it down. So the constitutional amendment says two things, well, a couple of things about removal of sheriffs. First off, the amendment says it doesn't change the power of voters to recall their sheriffs. So currently, right now, we voters, if we are not happy with our sheriff, we can ask for a recall. And how that works is that, for example, if I'm not happy with my sheriff and I have family and friends who also aren't happy with my sheriff, if I get enough signatures and the amount is 40% of voters who voted in the last sheriff's election, if I can get 40% of those voters to agree with me that we should recall this sheriff, if I can get 40% of those voters, then I can present my petition to my county election office, and that recall will be on the ballot. So if 51% of voters believe the sheriff should be recalled, then the sheriff will be recalled. So the amendment doesn't change that at all. We keep that power as voters to hold our elected sheriff's feet to the fire if they're engaging in misconduct. What the amendment would do, though, let me tell you how the current law is and what the amendment would do. So currently, if a sheriff is engaged in shenanigans, right, behaving badly, there are two alternative routes for that sheriff to be investigated. And so the first is the amendment has this really strange Latin term. Emily, I'm probably gonna, I don't even know if we learned this term in law school. It's a quo warranto legal proceeding. So it's, in short, it's an abstract proceeding. It is a legal proceeding filed in court that asks the court to investigate a sheriff who might be going rogue. And ultimately, at the end of the day, it's the judge who's going to make that decision. It is a legal proceeding. So currently, both our local county attorneys and our attorney general have the power to initiate an ouster proceeding. What this amendment will do is take that power away from all of our local county attorneys and concentrate that power in the attorney general. So currently, both the attorney general and our local county or district attorneys have the power to initiate a proceeding against a sheriff. This amendment would take that power from all local county attorneys, and they would have absolutely no power to initiate an investigation. And so, you might be thinking, well, so what's the big deal here? Think about how law enforcement district attorneys, they work. Well, they work together, okay? Sheriffs and district attorneys work together every day, right? They're in the job of law enforcement. And so who would probably know if a sheriff has mishandled evidence or tampered with evidence, right? Or done something, engaged in some sort of misconduct? Well, probably the local attorney is going to know that, right? Probably not the attorney general who sits in Topeka most days. And so it's going to be these local county attorneys who know when to call out a sheriff. And so if this amendment passes, what that means is if you have a local, let's say you have a local county attorney in Western Kansas who believes that a sheriff is up to no good. Well, if that local attorney calls the attorney general in Topeka and says, hey, will you start one of these ouster proceedings? Well, if the amendment passes, the attorney general, whoever that's going to be, it's either going to be Chris Mann or Chris Kobach, the attorney general can say, nah, we good. I kind of like that sheriff down there. I'm not going to start an investigation. And that local county attorney who had no power whatsoever to initiate an investigation into a sheriff. So at the end of the day, that the sheriff's amendment would take away power from our local county attorneys and concentrate that power into one office, the attorney general.
Thank you so much. And kind of to circle back around from a previous question, what would a no vote or a yes vote mean? And what would these do?
Well, I think Emily put it the best. A vote no is a vote for the status quo. So a vote no would continue to, would mean that local county attorneys would continue to have the power to initiate an investigation into a sheriff and the attorney general. They have concurrent power currently. Both of them can. So a no vote would keep the status quo. And a yes vote, like I said, would take away power from all of those local county attorneys and give that power to the attorney general solely and exclusively.
If this amendment were to pass, what would happen next with the selection of sheriffs and potential local control?
Well, if the amendment passes, at least with respect to the election of sheriffs, it's not going to change anything unless a county and a city government decide to consolidate. So it's happened one time. And I know some of you are thinking, what about Wyandotte County? They're a unified government. It's a little bit different. So when I'm talking consolidation, it's a specific set of statutes under Kansas law. So it hasn't happened very often, right? It's happened one time back in 1974. So really, even if the amendment passes with respect to the election of sheriffs, I don't see it changing all that much because 104 of the counties already elect their sheriffs. It would just require going forward that they continue with that process. The only change it would have with respect to elections of sheriffs, again, is if a county and a city government decided to consolidate under those particular statutes under Kansas law. And then they'd have to have an elected sheriff as their top law enforcement person, not a law enforcement agency board picking the police director.
We're going to go on to audience Q&A after this question. So if you have questions, please use your index card to submit those. You can give those to my volunteers in this room, or you can raise your hand if you need a card. If you're watching this online, please send your questions through the Q&A feature on Zoom. With that, we can go on to our final question is, where can we find more resources to educate both ourselves and maybe potential family members or friends on this issue?
Thank you so much, Professor Castle, for artfully explaining the sheriff amendment. You know, I said this twice already, and I'm not just going to keep it to this, but really a great place for you to go is the Kansas Legislature website. They have it, and if it's easier for you to look up, like I said, it's you for the legislative veto, you'll want to look up HCR 5014. For the sheriff's amendment, you'll want to look up HCR 5022. There you will be able to locate testimony from both proponents, opponents, and neutral parties and their thoughts on these two amendments at the time, the bills. But I think, you know, another great place to look is local news. This morning I was looking at the Lawrence Times, and I saw that there was an editorial written by a local sheriff on the sheriff's amendment. If you have strong feelings for or against a certain sheriff, or you have strong feelings for or against a legislator, if they've written an editorial in the local news, I would highly encourage you to go read that and hear their thoughts on it, to become a more civically engaged, knowledgeable person on these two amendments. And I bet Professor Castle has more awesome resources, but those are the two I have.
Well, actually, my go-to is Ballotpedia, and it is an incredible resource to find out sort of about the amendments and all things related to. And one feature of Ballotpedia that I thought was kind of interesting, I haven't actually laid eyes on this because I haven't had a chance to research it, but somebody came up to me and said that Ballotpedia actually evaluates the level of difficulty of text of constitutional amendments. And if you look, for example, at either the legislative veto amendment or the sheriff's amendment, if you actually read that, good luck. I mean, I'm an attorney and a law professor, and it literally took me like a month to really dig in and figure out what was going on. But apparently Ballotpedia has rated our Kansas constitutional amendments as needing a PhD to be able to figure them out. Not yeah. So yeah, good resources.
Fantastic. And now we will take some audience questions. Yeah. How costly are one of these amendments to put on the ballot, and how can voters influence amendments added to the elections?
I don't know how costly it is, but how you voters can have some input is who you elect as your legislators. Because again, it takes a 2/3 majority to put a constitutional amendment on the ballot. So really your power, your control is who you are electing as your state legislator.
Thank you.
Hopefully we don't get super. Hopefully we don't get super political here, but what groups are in favor of the sheriff's amendment?
Our Douglas County Sheriff, who just published in the letter to the editor in the Lawrence Times. So, and that's a good question. And for me, I get to say that I'm not going to get political, because when I decided to research these amendments, both both the legislative veto and the sheriff's amendment. I decided to actually not try to figure all of that stuff out. I wanted to focus on the statutes. I wanted to focus on the amendments. So I haven't done a deep dive on with respect to the sheriff's amendment as far as who is, it's a mixed bag. And the thing is, you know, it's a double-edged sword for everyone involved. I mean, whether it passes or not, you're always going to have potential, you know, I don't want to say abuse of power, but people trying to, you know, hedge the system. So I don't know which groups, but like I said, I know that our Douglas County sheriff absolutely is urging a vote yes on the sheriff's amendment. Do you have any research on that?
Okay. Do you know if any sheriffs have been removed by a local DA or AG in recent history? If so, why?
I don't think in recent history. I'm sure that I've probably and here's the deal. So I've actually talked to a couple of district attorneys to get their thoughts on this. And in reality, if you have a local DA or a county attorney who believes that a sheriff is doing bad things, it's probably not going to be that local attorney who is going to file the ouster proceeding. They're probably going to get another county attorney in, because that attorney is going to have to continue to work with the sheriff. They have to have a good working relationship. So usually, and I say usually like it's happened a lot, but if something like that, if a local county attorney thought that the sheriff was doing bad things, they probably get sort of a more neutral party involved. But the point is if the amendment passes, they can't even go to their neighboring local county attorneys and ask them to get involved.
What does a review of agency rules and regulations by the legislator actually do? Do they currently have any power to change any of the rules and regulations?
Yes, by passing a law.
That's exactly what I was going to say. You know, as I stated earlier, the legislature already has the power to review these rules and regulations promulgated by administrative agencies. They have the power to change it by statute. And so to a large extent, this power is already there. It may not be as extreme as revoking and suspending without presentment to the governor, but the legislature already certainly has this power, as Professor Castle stated.
And I think it's when we talk about, Emily and I have used this word promulgated agency rules and regulations. You know, when you're in law school, if you take administrative agency, you learn how rules and regulations are promulgated. And it's not just somebody sitting at their desk saying, oh, I think this is a good idea. Many of those rules and regulations go through public comment and hearings even. So many of those rules and regulations have been pretty well vetted by these executive state administrative agencies.
Thank you so much. Donovan, we're going to have you pass the mic to an audience member without a question.
Thank you.
Mhm.
Thank you. So the governor says there's a separation of powers problem with the rules and regs amendment. And my question is, if that amendment passes, can the Kansas Supreme Court step in and toss the amendment because it's unconstitutional or some other problem?
Well, the frustrating thing, and Emily alluded to this, it is a separation of powers issue. And the Kansas Supreme Court, as Emily said, in 1984, in a case called Stefan versus Department of one of the administrative agencies. So the Supreme Court has, with this very action, right, giving the legislature a 51% control over revoking an agency rules, the Supreme Court said it is a violation of separation of powers. And guess what? Our Constitution hasn't changed since 1984. When we amend our Constitution, we just add to it. We don't go back and change it. So our Constitution hasn't changed in that regard. So, you know, when I started doing this research, And I came across this case, this 1984 case, and I actually emailed an attorney way smarter than I am. And I was like, how can this happen? The Supreme Court has already said that this is unconstitutional. And this attorney said, that's the whole point, amending the Constitution. And so here's the deal. I have a feeling if this amendment passes, the first agency rule that is revoked by 51% of our legislators, there's going to be a legal challenge. There's going to be a legal challenge. Now, what the courts do with that, because again, this would be amending our Constitution. It's kind of hard to say that it's unconstitutional when that is actually now a part of our Constitution. But at the end of the day, I don't know if there's a legal argument run around to with this separation of powers argument. And even though the Constitution has been amended, there's still the separation of powers, the idea that we have three co-equal branches of government, and this would upset that separation. I don't know what a court would do with it, but I guarantee the first agency rule that's revoked is going to be challenged. Whether the courts will have the power or the legal position to call it unconstitutional.
Is there a hierarchy of constitutional rights?
Can you repeat the question so the people online?
The question was, is there a hierarchy of constitutional rights? No. If an amendment is just as solid as the text of the Constitution. So, good question.
Thank you so much. Do these administrative rules and regulations developed by state agencies have the force of law?
Yes, I'll give my brief overview of that. This is something that I feel semi-qualified to talk about. I feel like it's maybe law school 101, but there are various ways laws can obviously become law. The most obvious is it goes through the legislature, and on the federal level is signed by the president, on the state level is signed by the governor. But both on a federal and state level, there's these administrative rules and regulations that are law. That's actually an entire law course at KU called administrative law. They do have the force of law, and that's I mean, yeah, I don't know how much more I have to say on that. I don't know if Professor Castle has any more insight.
Yeah, they do have the force and effect, but again, going back to what's the function of the executive branch, right? Because those administrative agencies are executive administrative agencies. So what is the purpose of the executive branch? To enforce the laws that the legislature passes. So the legislature passes general laws, right? And then says, hey, you smart people over that agency, you figure out how to actually implement, make this work. And so, yes, these agency rules do have the force and effect of law, because you'll get in trouble if you don't follow them, right? But the purpose is to enforce those laws that the legislature has passed.
In states that have passed legislative veto, has the veto been used, and what policies has it been used on?
My research has not delved into exact policies or rules or regulations that, for instance, Idaho and Connecticut have used the legislative veto to override administrative rules and regulations. But I would encourage you to go look at those two states. Go look at their amendments. I think Idaho had a very similar language. It was in November of 2016 when they took that vote. I believe that vote had passed by 55%. Very similar wording in the amendment that they used. I'd also say go look at the states where the legislative veto has not passed. Those include, if I have my list right, Alaska, Oregon, and Missouri. Those are good states to look at for what the legislature has used their legislative veto for. And obviously in the states where it hasn't passed, you can see if you can delve any information off of that.
And kind of a follow-up to that. So when Idaho and Connecticut passed similar legislative vetoes, was there a challenge? And doesn't the US Constitution guarantee that every state Correct. Of a Republican power of government. And isn't there a separation of power part of that?
Well, when we're talking about the federal government and separation of powers, the federal government can't tell states what to put in their constitutions, right? That's a state's right, if you will. So when we talk about the federal government and separation of powers, that's not part of this particular conversation. So I forgot the rest of the question.
I can repeat it. So when Idaho and Connecticut passed similar legislative vetoes, where are their challenges? I'll break it down into like 3 separate questions.
I do have information on that. What I had written down was that it had been in effect in Connecticut for about 10 years. But it became vulnerable to a challenge in Maloney versus Pack, which invalidated the regulation review process on constitutional grounds. And essentially, the purpose of that amendment in the Constitution now in Connecticut, is stated by experts in that state, has been to reaffirm the constitutionality of their regulations review committee. So that type of review power that the Kansas legislature currently has right now. And in Connecticut, it just reaffirmed that power once that court case invalidated it.
And you did some research, Emily.
And I think that answers that question. Thank you so much.
Great explanation, like Ms. Castle just said. Would the state legislator be able to intervene when the governor appoints to and head an agency if the amendment passes?
I don't think that this amendment would affect that at all. It wouldn't, I don't think it would change that power, right?
And then this is going to be our final question. Are citizens prohibited from gathering signatures on a petition to hand constitutional amendment questions placed on ballots?
Not of which I'm aware. I think that would be a violation of our First Amendment right. So I think so. Yeah. I don't see that as any sort of being against the law.
Okay. Thank you so much.
And as we wrap up questions both from ourselves and the audience, I wanted to ask both of you if you had any closing remarks on any of these 2 amendments or any messages you wanted to send out to voters before November 8th.
Vote early.
Vote early and be educated.
I want to thank both of the panelists for their time, and I also want to invite Emily Wilkinson with the Kansas Interfaith Action up for her closing remarks. Thank you.
Well, I want to thank again our moderators, the Hedge of Faith from Ladlight, for presenting this important educational event to us this evening, as well as our very knowledgeable Professor Amy Castle and Emily Depew for giving us those thought-provoking answers. I'd also like to recognize tonight's event organizers, many in the room with us right now, Sonia and Carol from the League of Women Voters of Lawrence Douglas County, Laurel with Main Street Coalition, Donovan with Loud Light, in addition to our Loud Light moderators, and other co-sponsors of this event included Kansas Interfaith Action, as well as the League of Women Voters of Johnson County and the League of Women Voters of the Wichita Metro. As was mentioned at the top of the program, this panel is the second in a series of educational events that these organizations are hosting in anticipation of the November 8th election. And we'd love for you all to join us for our 3rd and final event focused on these 2 constitutional amendments, either in person or online, November 3rd at Wichita State University. And as a reminder for everyone in our audience, early in-person voting has already started in Douglas and Johnson County. And November 1st is the deadline to apply for an advance mail ballot ahead of the November 8th election. Thank you for attending this evening, and good night.